the things that the lawyers are learning here in these 4.5 days of intense training is something that they've never learned in law school, and many of them never had the opportunity to get the personal mentoring that this program gives in the law firms that they work. So this is really an opportunity to get young lawyers who are interested in trying cases the empirical opportunity to learn from the very best that this country has to offer in terms of trial lawyers. The mentors that we have here at the program, every year we have 5 from the plaintiff's bar and 5 from the defense bar, and they are the top trial lawyers in their specialties from all over the country. These kids, these young lawyers, have an opportunity to go with our mentor-student ratio is 1 to 3, so they get personalized, individualized training from both sides of the bar. So a lawyer that does strictly a defense side in his practice will get benefits not only from a nationally prominent defense lawyer, he'll also get the critique and the advice and judgment from a nationally prominent plaintiff's lawyer. That's what makes this program unique among other trial programs that exist throughout the country. And we're here at the National Judicial College, where we have the state-of-the-art 21st century courtroom. The facilities are just not anywhere else like it anywhere else in the country. So the students are afforded not only great teachers, but a great place in which to learn over these 4.5 days.
I really thought that this seminar, I've been to a trial academy before produced by other people, and really expected much of the same. A lot of going through technical aspects. What I really liked about this seminar is that the instructors were incredibly experienced. You just sit and you're in awe of the talent of the instructors in this course, and they really highlight the strength of the presence, the oral argument. It wasn't so much about the technical aspects. Everyone who's here already knows the technical aspects of how to do a trial. It's really about how to improve upon our presence in the courtroom. And I'm really in awe of the instructors, and that the course didn't try to make them do the same thing. Everyone is different here, whereas the other course I've been to, it was sort of, we're all going to teach the same way. Here, everyone acknowledges that we're individuals and that we all have our own strengths, and really tries to impress upon us the importance of highlighting the strengths.
I did some research on this seminar, and I knew what sort of a faculty was going to be here. So I was most excited about seeing these masters come in and teach us what they know, show us examples of how to do the myriad of different trial techniques and strategies, and just to talk to them about how they feel about relating to a jury, how they feel about getting their point across and persuading the jury, and I certainly have not been disappointed. When you have somebody like Larry Ottaway or any of the other presenters here tell you what you did right and what you did wrong, it's both personally satisfying and it lets you know what you need to improve on. I was lucky enough to do the appellate argument in front of the Chief Justice of the Nevada Supreme Court, the former Chief Judge of the Ninth Circuit Court of Appeals, and the Dean of the Law School here in Nevada. And to do that and to get their feedback and their critique of you, your style, your content, is certainly something you're not going to get anywhere else. Nobody likes to see themselves on tape, but once you do, and once you take a look at how you are in your mannerisms and the presentation that you are making to the camera, which is in fact the jury and your audience, it allows you to change, it allows you to get better, it allows you to make the corrections to make you a better attorney.
I've watched the students that I've had, and I had 3, go from people who didn't ever have experience with the system to people who have done every phase of it: voir dire, opening, cross, direct, closing, trial argument, appellate argument. I've watched them grow in confidence and stature. I've watched their reasoning sharpen, their persuasive abilities increase. When I was a kid, we tried 18 cases a year. And now a person 30 years old in a law firm is lucky if they've second chaired one case, even seen a trial. at least this gives them the chance to do that in an environment where they've got some people to teach them, they've got some time to appreciate it, and they don't feel like if they blow it, if they've stretched their wings a little and try something, that